Okay, Ashley, good to see you. Let's break this down right now. This is a very strange case for a lot of different reasons. The 911 phone call, what did you make of that?
Jesse, if I'm a juror, I can hear the panic in her voice. When she says the breathing is almost gone, you could hear her voice almost shaking. I find it very convincing.
Yeah, I mean, she broke down in the courtroom, and the jury sees that.
Right.
Right? Because is it clear right now, if you're sitting there, that this is a case of child abuse or her falling down? These are significant injuries. And if that's the case, is it then a question of who did this? What do you think of it?
Well, absolutely, and I think it becomes an issue of credibility as well. Hearing the defendant's voice and mannerisms during that call, I think, can be very moving for a jury.
Yeah, I agree with you. And look, this is just part one of it. We're waiting to go see this police interview, and maybe we'll have an opportunity to talk more about the police interview from yesterday, because it was very aggressive, and there were some very strange points to note. Yeah, shocker, he's not going to go pay that. Thanks, Rachel. Let's talk about this, Ashley. So, you tell me. I'm confused. All right, you tell me. Is this really how a state attorney's office drops charges? Because they're saying that we do this like with everybody else. He didn't get any special treatment. What do you think?
Listen, this case is completely bizarre. Every time I think about this case, I think of the old saying, it's better to be rich and guilty than poor and innocent. And I hate to say that, because as an attorney, we want to believe that the law applies equally to everybody. Unfortunately, I don't know if that's the case here, but this is what I don't want to happen. I'm concerned that the public is going to have a chilling effect on bringing hate crimes forward. And
that's a good point. We don't want that to happen, and that's one of the criticisms. That's one of the things the police department's so upset about, this discrepancy between the police department and the state attorney's office. It's really getting ugly. They've called for the police union has called for the resignation of Kim Fox. We'll have to let you know what happens. Okay, so this is the second time the jury's seeing a police interview with Lindsay Partin. I'm curious, Ashley, what do you make of it? It's kind of hard to hear a little bit here and there. We're getting the main crux of talking about how she cared for this young girl. She never saw any bruises, never said anything about disciplining her with violence. It seems pretty straightforward. It doesn't seem like evidence of child abuse based upon what she's saying. But what do you make of everything?
I agree, Jesse. I think at this stage, it's hard to tell. I'm looking at her body language and seeing how calm and collective she is, which smells a little bit funny to me, to be honest with you, given her police call just the day before. But I think it's going to come down to what the jury thinks of the way that she's acting during this interview.
Are you saying she's talking too much? Because one of the things that we discussed is she may take the stand in her own defense if the defense ultimately feels, you know what, we just haven't raised enough reasonable doubt here. And she believes that she needs to take the stand. Does this show that she might not be a great witness on the stand?
Well, that's a good question. I think it could cut both ways. I think the jury would probably like to see her testify, but at the same time, if she says too much, it may hurt her.
Well, every jury wants a defendant to testify. And here on Law and Crime, we want every defendant to testify. The problem and I'll tell you this, in most of the trials we've covered, when a defendant testifies, it doesn't work out so well for them. But here, this case, she has to come off as credible, and she even became emotional when that 911 phone call was played yesterday in court. I would imagine the same thing would need to be, if she took the stand, she would need to show that emotion.
I agree. I think that would play well with the jury, to see that she has some sorrow and remorse, and that she is allegedly innocent.
Now, what do you think about the charges here? You know, she's been charged with involuntary manslaughter, murder, and 3 counts of child endangerment. But based upon the charges, the prosecution doesn't need to show that she intended to kill this girl, but that it was a result of child abuse. Does that help the prosecution's case? Can the defense work with that? I mean, it seems tough for the defense.
I think so too. I think in this case where the defense is relying on these 2 instances that the child had previously fallen a day before and 2 days before, that could kind of cut both ways as well, because perhaps, although they don't have to show that this was premeditated here, they almost can. The prosecution can spin that and say that she was planning this all along. She reported twice, not once, but twice to the father that there were these alleged falls. Was she planning this the entire time, or did those falls really occur?
You know, and it's funny watching this video in light of what we saw yesterday with the first interrogation tape that became very combative between the detective and Lindsay Partin. I mean, even accusing her at one point of not making that 911 phone call until an hour and 20 minutes later, when in reality she did make the phone call only a minute or so after calling the father. So the jury could look at that and say, oh, this investigation, they were already blaming her at the very beginning.
That's true. And as an attorney, I don't think you ever want to be hostile with a witness, because now you're making the defendant a victim. And the jury feels that, right? So I don't know if that was necessarily a good play on their part.
Well, I mean, they couldn't cover it up. It was part of the interview, and that's the interesting part. So this is part two. And what we are waiting for is to see if the defendant, at some point in this interview, admits to hitting this girl at some point. We've all been waiting for it. I believe the prosecution made that point in their opening statement. We have a lot to break down from this interview. Ashley, she is getting up. She's demonstrating how Hannah fell. She's giving an indication about what may have caused these injuries, but she appears to be very animated and also, in my opinion, giving sometimes inconsistent statements. What do you make of it?
I agree. I think a lot of the statements here are inconsistent. I think her story is becoming a little bit complicated. Juries like simple stories. There's a fall 2 days before, there's a fall the day before, none of which are necessarily consistent with shaking, which is, of course, the prosecution's theory.
She mentioned that she shook her after she collapsed. But here's the thing. The other way to look at it is she's been very forthcoming. She could have lawyered up. She didn't. She could have not handed over her phone. She did. She could have not told the police not to search her house. She was very forthcoming with everything. Is that suspicious or not? I mean, because then the upside is if she was completely silent and hid up, maybe she had something to hide. So how are we supposed to look at this?
Well, that's a good point, although I think in a situation like this, where the accusations are that she abused the child, I don't know that there would be too much evidence in her home or her phone anyway. This is an individual act that's not necessarily involving any other individuals, obviously, except for the person who's abused. I don't know that they would have found anything anyway. I don't know that she had anything to hide in either of those resources.
What's weird is the prosecution is saying on the day in question she shook Hannah, right? And that
Correct.
probably contributed to it. But they also, and hit her as well, but they were indicating that she had hit her on the days before this as well. And the thing I don't get is if she was abusing Hannah, wouldn't the father, Jason Weshy, have stopped this? Why would he keep bringing her over unless Partin kept telling him, oh, all these injuries you see on her, she fell. I mean, does it make sense to you?
That's right, unless the father didn't know for some reason. And then the question becomes, Hannah's 3 years old. Was she verbal enough to explain anything that was going on to her father? I don't know.
Well, the fact that we say I don't know, is that reasonable doubt?
Well, that's a good point, Jesse. I think it is.
I mean, that's the point. And the question is the defense doing a good enough job right now, because we believe that they are going to call their own expert witness, Dr. Werner Spitz, to say, hey, I have an alternative theory about what ultimately happened with Hannah's injuries, so I don't know. I don't know where they're going to go with this.
Well, I agree. I think right now those two falls don't seem significant enough from what we've heard thus far to result in this child's death. However, I am interested to see what the defense expert says about that.
Got a long way to go. We're still listening to this police interview and waiting to see if at any point she admits to actually uppercutting Hannah or poking her in the chest, which is what the prosecution has claimed she admitted to. Let's take a break. We'll be right back right after this. Now we're starting to see the flavor of what we saw yesterday. Actually, these interviews are getting combative, and you have to argue they're getting combative for a reason. I mean, you have a young girl, a 3-year-old, defenseless, who was taken into the hospital with really traumatic injuries. They're not buying her story, or is it that they're thinking it's her, or are they thinking it's the father right now? What do you make of this?
I think there is some suspicion surrounding the father, but I don't necessarily think that Lindsay's story is adding up just yet. Like we spoke about before, there's a lot of inconsistencies.
Yeah, and I think that's a big issue for her. I mean, the prosecution has been putting on a pretty strong case so far. I mean, with these experts who are saying
that's right.
That's a big issue here, that it doesn't look like it's from a fall.
That's right. We had the pediatric radiologist testify earlier that this was the result of abusive head trauma. And
the same thing from the forensic examiner as well. All right, this is an interesting development about whether or not he can choose to be present, waive his right to an appearance at any future pretrial hearings. Now, Ashley, the way that I understand this is it's a situation where the defense doesn't want him to appear. They've argued, from what I understand, that it's just going to create unnecessary hardship and attention to this trial, especially for the families of the Parkland shooters, the shooting victims, and the prosecution wants him there. What can we make of this?
Well, that's what I was wondering, because I think the prosecution should have an interest, and does have an interest, obviously, in protecting the families of the victims as well. So I'm interested to hear a little bit more about what the prosecution's argument is. But yeah, it's definitely interesting.
This whole case is, I mean, this is not about, as far as I understand it, it's not about guilt or innocence. I mean, he confessed on tape to what he did.
Right.
The evidence against him is very strong. Isn't what's happening right now a determination about whether or not the state will go forward with a plea deal where they take the death penalty off the table? Because his life is over, clearly. It's just a question if it'll be life in prison without the possibility of parole or the death penalty.
That's correct. I understand he's willing to enter into a guilty plea if it's life in prison. However, prosecution is very gung-ho that they want the death penalty for this guy.
Okay, so what you're seeing is a back and forth. What I think is happening right now is a determination if certain information, certain sealed records, maybe about mental health of the defendant, could be shared with other people in the investigation. These are the pre-trial hearings. This is a very standard, but also this case is unlike anything we've ever seen before. And Ashley, I mean, let's just talk about the main idea behind this case. Is the defense is urging the prosecution to accept this deal, where, again, he will plead guilty to the 17 counts of murder, 17 counts of attempted murder. Doesn't have to be a trial. You don't have to expose all the family members of Parkland, the victims of, to a trial, which can be very difficult, if you just take the death penalty off the table. But the state has refused to do that. Why do you think they refuse to do that?
I think the only reasonable explanation here could be that the evidence that they intend to put on at a trial is going to be so egregious and so inflammatory to a jury that they believe that they can get the death penalty here.
But is that the right call here? I mean, to prolong this? Do people want to keep seeing this in the public eye? One of the things we're talking about today is his defense is trying to make a motion that this guy, that they don't want their defendant, they don't want their client to appear at any more pretrial hearings. They're saying it's just adding unnecessary attention because every time he appears in court, the cameras are on him, the family members of the victims see him. Is there an argument to be made there?
Well, of course. I mean, I think on one side of the coin, you could say this man's life is taken from him in either circumstance. Why does it matter if it's the death sentence or life in prison? On the other side of the coin, I think that the defense's argument could also be, or the prosecution's argument could be that when you do get a life sentence, there is a possibility that you're going to get out before life.
Well, I mean, if life in prison without the possibility of parole, I mean, his life would
Correct.
be done. The question is, it's just what kind of future would he have? I mean, is
Right.
death the appropriate sentence, the appropriate judgment for a man who went on a, allegedly went on a shooting spree that claimed the lives of so many people? That's the question.
That's the question, and it all comes down to what kind of evidence that they have and what a jury would believe.
All right, one of the things that's being argued today, and it's a little weird, is the defense obviously is gearing up for a mental health defense here, and they're having experts to evaluate Cruz while he's in jail, but apparently they don't want the prosecution to know the identities of these experts just yet. And actually, that's weird. They're saying if we eventually decide to call them at a trial, obviously we'll let you know who they are. But at this point, we don't want you knowing who they are. It's none of your business. What do you make of that? Is that true? Is that a fair argument?
Well, I don't know, Jess, because at this stage, we're in the pre-trial stages right now, and you can't have a trial by surprise. So if they do intend to offer the testimony of these experts or these evaluations, they better do it pretty quickly.
Because is it their business to know what their strategy is at this point?
Well, the other side should have an opportunity to get their own evaluators and their own experts and have an opportunity to rebut those evaluations and those opinions.
Yeah, it's a weird day in terms of hearings. One of the other things that we see happening here in this hearing is that the state is asking the court to release certain records, like school and hospital records, to law enforcement investigating the case. Now, that seems to be pretty straightforward. Even if these are secret records or sealed records, you have to. It's still ongoing. I mean, this is not an open and shut case. Even if it's in the public eye, they still have a case to put forward if this goes to trial.
That's right. And there's a continuing discovery obligation, as you know, to share the documents, the testimony, the evidence that you intend to put on at trial with the opposing side. Do
you ever get the sense that, a case could seem so strong at the beginning, but as a prosecutor, you can't be distracted by that. You still have to meet the elements of the crime and show it. And sometimes people are surprised when there's an error in a prosecution's case because is it a sense of, we we thought we already had him, but there's just technical procedures you have to follow.
That's right. And you can never predict what one of the witnesses is going to say.
That's a really good point. And, you know, it's an interesting case from a lot of different levels. Also, seeing Nikolas Cruz, he appears very different. He looks very different than he did when we first saw him. Apparently, you know, it's interesting to see defendants, how they appear after being in jail for quite some time. And he looks, I mean, in my opinion, he looks like he put on a little weight. His hair has grown out a bit. Your thoughts as you see this today? Because it's pretty surreal watching him in court. It
is, and I think he appears, we know that he's a young kid, but seeing him live like this today, he looks young, he looks fresh, really, and it's shocking, I think, for myself and for a jury to look at him and understand that he's admitting that he did this.
So as we talk about the defense's mental, you know, evaluation, we believe they're going to be putting on a whole defense based upon this. The question, I don't think, Ashley, is about insanity so much. I mean, maybe they'll try to argue that in a trial phase, but when you have him on tape admitting to what he did, it's going to be hard for them. So do you sense that more of these mental health experts who might be visiting him in jail, this is a way to mount a defense in terms of the sentencing phase? Because it's a question of whether or not he would face life in prison or the death penalty.
Perhaps, and maybe at the sentencing phase, they can bring in all this evidence and show that he's more, you know, he has a better opportunity for rehabilitation if he has life in prison and he can get treatment and have other professionals come in rather than just taking his life completely.
I mean, it's a weighing determination. Aggravating factors, mitigating factors, this is what ultimately happens in a sentencing phase. You have to also account for the fact that he's 20 years old. He's young. I think he had a difficult past at some point. So those are considerations, but you can't forget the fact that if he's found guilty, that means the jury found him guilty of murdering 17 people and attempting to murder 17 others in one of the now most infamous, egregious, and heinous crimes we have seen in America.
That's very true. And we could also, I think that our country is in a climate where we don't only want to punish people for their wrong, but we want to rehabilitate. We want to make our country better. So if this defendant does have an opportunity to rehabilitate himself and get better in prison as opposed to a death penalty, I think a juror would want to give him that opportunity.
Well, we'll have to see. I mean, you know, right now this is all determination. I mean, there's a lot of different arguments being made in the court, but one of the things the defense is saying is they don't want the prosecution knowing about any of their experts that they're bringing to that jail to do a mental evaluation of the defendant, because they might not call these witnesses at a future trial. It's none of their business at this point. Let's see what's happening. We'll go back live. Now, if I'm understanding this correctly, the state wants all these kind of records released to law enforcement during this investigation, but the defense is saying a lot of this is privileged. They don't have a right to this information. Some of it, I think, is they're trying to say is, you know, in terms of the physician-patient confidentiality, also attorney-client privilege. Who's right?
Well, if these documents are subject to the attorney-client privilege, that's one of the most sacred privileges that we have and that we're afforded when we have an attorney. If they are under that privilege, they do not have to be produced. But like I said, if they do produce these documents at trial, if they intend to introduce this evidence, they're going to have to turn it over.
Yeah, no, it's still in the beginning stages of this. And you and I were talking that a trial for Nikolas Cruz wouldn't even begin until next year.
That's right.
I know it takes longer probably in the criminal sphere than maybe in the civil sphere, but again, seems like a long time. But then again, I mean, look what's happening here. There's so many minute details that they have to go through, and this is a complicated case in terms of mental illness and multiple counts. I mean, this is not a straightforward case.
It's not, and there seems like there's a lot of pretrial issues that they're going to have to sort through before we even get to the trial. Mass murder of over 14 people. So there's a lot of things that have to be sorted out before we actually get to the trial here.
Yeah, absolutely. And again, we just see Nikolas Cruz there. And what's going to happen when the judge asks him about if he voluntarily waives his right, and knowingly waives his right to appear? I mean, what happens there? Because the question is, his defense team doesn't want him to appear for any more of these pretrial hearings. They said, hey, listen, it's just causing unnecessary attention to this court proceeding. Also, it's not fair to the family members of the victims every time they see him in court. What would the judge have to do when asking Nikolas Cruz these questions?
Well, the judge is going to have to evaluate a myriad of things, right? whether or not it was voluntarily and knowingly. Was he mentally competent to enter into that waiver? Was he under the influence of any drugs or alcohol? These are all questions that she's going to have to ask and have answered before she can make that determination.
And Ashley, isn't that key, what he just said? I know you didn't intend to do anything. I know you didn't intend to hurt her, but you did hurt her. And she admitted in the last part of the interview, I slapped her upside the head. She was frustrated about the ketchup in the toilet. So what do we make of this?
That's right. I mean, she's just admitted that she's slapped the child with an open hand. I think the prosecution is going to have an absolute field day with this. The defense, the crux of the defense here is that the child has fallen on 2 prior occasions, one from a 12-inch platform and one from an 8-inch platform. That's smaller than a piece of printer paper. I wasn't buying it before, but I'm definitely not buying it now after that admission.
What is the defense going to do about this video, this interrogation? How do they cross-examine this witness?
I think that they have to have a really good expert come on and testify that this was a prior injury, the slap had nothing to do with it, and this was not the result of abuse, but that it was, in fact, a result of these small alleged falls.
Well, we do believe that they may call Dr. Werner Spitz, a renowned expert in this field who testified in the Casey Anthony case, and we all know how that one went, so we're going to have to see. Ashley DiLiberto, thanks so much for coming on. It was a pleasure.
Thank you so much for having me, Jesse.
Of course.